the accused senior officer, Major General U.M. Mohammed, N/8656, is therefore found guilty as charged in count 13. Count 14, count 15, count 16, count 17, and count 18 will be taken together. These counts were all charges of criminal misappropriation brought under Section 308 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89. The counts are all alleging the dishonest misappropriation of various sums of money from FCCL Napil Properties Limited, Access Bank number 076-991-1478, being monies paid by subscribers and Central Bank of Nigeria Staff Multipurpose Cooperative Society for the Asokoro Hills Smart City Project. The testimony of Sani Danjuma, who was prosecution witness 19 before this court, and Exhibit P16 series tendered during the course of the trial through him, depicts clearly how a total sum of 2,500,000,000 naira only was paid by the Central Bank of Nigeria Staff Multipurpose Cooperative Society to FCCL Napil Properties, of which the accused senior officer was a director and the chairman. The testimony of one Fatima Ajibade, who appeared before this court as prosecution witness 23 from Access Bank PLC, shows that various sums of monies were hasted from the accounts to various entities for reasons not connected with the development of the Asokoro Hills Smart City project. The defense of the accused senior officer is that he was remote from the account and had no dominion or control on the transaction of FCCL Napil at Access Bank. The court notes that in the circumstances, as a director and chairman of FCCL Napil Properties Limited, and the transfer of various sums of money took place over time, the defense of not being in control does not avail the accused senior officer. The court also notes the advice of the learned judge advocate on how companies operate and holds that this defense is not tenable. The accused senior officer is therefore found guilty as charged on count 14, count 15, count 16, and count 18 as charged. In consequence, therefore, and in accordance with Rules of Procedure 43, Sub 1 of the Rules of Procedure Army 1972, the alternative counts to count 14, count 15, count 16, and count 18 will not be considered any further before the special court martial. That takes us to count 17. The vital element of this offense is that the accused senior officer withdrew the sum of 750 million naira only from FCCL Napil Properties Limited, Access Bank account number 076-991-1478, being monies paid by subscribers and CBN Staff Multipurpose Cooperative Society for Asokoro Hills Smart City Project. No evidence was led, whether oral or documentary, to prove such withdrawal. Although the prosecution tendered Exhibit P16 Gov being the statement of account of FCCL Napil Properties Limited, Access Bank account number 079911478, from where the monies were allegedly withdrawn. The prosecution did not show the details or particulars of the withdrawal. It is not the duty of this special court-martial to go searching with a fine-tooth comb for evidence. The prosecution was unable or simply failed to bring out evidence clearly to the count. This special court-martial, therefore, holds that the prosecution failed to prove a vital ingredient of the charge. Count 17, therefore, fails. In consequence, therefore, the accused senior officer, Major General U.M. Mohammed, is found not guilty of count 17 as charged. The alternative count to count 17 is also predicated on the above element of withdrawal of the sum of 750 million naira only, which the prosecution has failed to prove. The alternative to count 17 is therefore not given any further consideration by this court. Distinguished members of this court, the prosecution and defense team, members of the press, gentlemen, these are the findings of this special court-martial in the case of the Nigerian Army versus Major General U.M. Mohammed N/8656. Just before I conclude, it is imperative to inform the accused senior officer of his right in line with Rule 71, Sub 5 and Sub B of Rules of Procedure Army 1972, which provides that an accused, if the findings of a charge is guilty, may address the court in mitigation of punishment before the court deliberates on the sentence.